Hello, everyone. Good morning and welcome to the Canberra Business Chamber's HR Connect webinar on employment relations issues. I'm Greg Harford from the Canberra Business Chamber, if you don't know me, and I'm really excited to be joined today by Tian Mitchell, who is one of the people who takes your calls, ringing us on our Employer Assist hotline. So, Tian, welcome. Great to have you here and look forward
Thanks,
to
Greg.
unpacking some of the things that you deal with day to day on the employer line.
Yep, sounds good.
So what I thought we'd do probably was just kind of talk through some of the sort of the top five questions that I know come
Mhm.
through to the team from employers, and we're going to start with long service leave. Now that's something that's simple in theory, but tricky in practice, perhaps. So why, Tian, why does long service leave continue to be such a source of confusion for employers, do you think?
I think the main part is that it's different per state territory. There's some states have really old acts, some states don't have proper acts that deal with it. Then we have to add on the complexity, we've got portable long service leave. So for particular industries, again, those industries are different per state, and in each state, they're different industries. You then have the accruals is different. So it might be 12 years, one, 7 years, another, how you accrue. So the the formula that I guess is used, full time, part time, casuals. Obviously, you need to use different accrual amounts. If someone's going from something that we see quite common is we've got a full time worker, they then go to on leave, they might have a baby, have a child, then they go back to part time, then they might stay on part time. And then when they're on part time, then they hit the long service leave. So there's a couple of different elements that you really do make for its complexity.
Yeah, okay. So it is quite complicated, particularly if you've got teams across multiple states.
Yes.
What's the best way to manage entitlements when an employee is changing roles or hours or location, do you think?
So it's really just to log them. If they're changing, let's say, just their hours, just make sure it's logged. And then what will happen is when it comes to the point of their tenure hitting whatever be the certain amount, then there's usually a formula. And most of the time, the online services, like the bodies for it, they actually have that formula and you can kind of type it in and it will work it out for you. Or you can reach out to, the advice line and we can assist you with that. But it's just about documenting it because you don't want to start calculating it too early. The only thing you want to know is the tenure. As soon as you start calculating it too early, if they change hours, they do anything, it's all going to change. So it's always at the point where they hit from the tenure, then we can look back at it, but just making sure that the actual hours, the work is documented. But that really fits into the documentation legislation that you must have. So you need to have the employees' records and keep employee records.
So most businesses will have automatic payroll systems or be using Xero or something to manage their payroll. But for those SMEs that perhaps don't have automated systems in place, have you got any tips for how they might go about tracking long service leave accruals?
I would say just set up something in Excel. It doesn't need to be fancy. The key thing is just making sure that you have all the information. Again, it is an obligation that employers have is to record the hours, the days. I'm pretty sure even Fair Work might have some templates that you can use. Especially for a small business, you don't need to keep it fancy. You just need to have the details. If you want to go fancy, there's so many software systems, so many platforms that can help you, and they will range from being suitable to a small business to a large business. But as simple as Excel.
Yeah. And of course, most businesses will be using an accountant, and I'm sure
Yes.
the accountants will have some advice too on which systems you might use. Tian, one of the complexities here in the ACT, of course, is portable long service leave, which you've mentioned. There's some changes coming in to portable long service leave with
Yes.
new rules for the hospitality and beauty sectors coming in
Mhm.
from 1 July. There's still a little bit of uncertainty around that, I think, but at the moment, I think employers need to be assuming that that's the case. Have you got any advice specifically for employers who are going to get caught up in the new system?
So it will just be making sure that you're registered. If it is you don't have any of the other industries as part of your portable long service leave now, then making sure that you register with the body. I believe it's ACT leave, making sure that you're documenting, you're going through that, and you're using the service that is there for you. It's hairdressing and I think beauty services and the accommodation and food. So what will happen is I think that they're extending out the services portion of the the industry, the portable long service leave industry. The others are building construction, I think cleaning services as well, and community sector. So it just making sure before it gets to that point, again, we don't have too much clarity on it, but we do have the date before it gets to that point. Look at ACT leave, look whether you need to register, and that will guide you in how to log all that information.
And it's important, I guess, to be aware too that there'll be a hit more or less immediately on your wage bill because you'll need to start making payments to ACT leave to manage some of those portable long service leave
Yeah. So
claims.
for those who don't know, the difference between portable long service leave and a company is essentially you're paying it to, and this is a very simplified version. So I'm sorry if I oversimplify it, but essentially you pay it to a body so they have the money. So when the individual they move from your business to another business doing the same role, it's not you transferring money to another business. It's already in that with that body for that individual.
All right. Well, look, let's come on to the second biggest call that we get in to the advice line. Let's talk about wages now. Wages and underpayment concerns are at the top of everyone's list. Everyone, I think, wants to pay their employees properly, but sometimes people make mistakes. And of course, the closing loopholes laws that the government passed a couple of years ago now have made compliance with making wages right a very serious issue. So, what are the key sort of wage payment related issues that have now been covered off in the law, and what do employers need to know?
So it's really about getting it wrong. So when this first came out, there was a lot of employers that were really scared because they've accidentally, gotten pay wrong or incorrect or missed things. And smaller businesses, there are things that you don't know, and you don't know what you don't know. So it's easy to make those mistakes. But the part in this is that it's intentional underpayment. So all of it, the wording that they've used is intentional. So it's not for employers who accidentally get it wrong. So they really have used that intentional wording. But still, that doesn't mean that you can just be like, well, you know, go off being ignorant. You still need to make sure that you're doing all the right steps, seeking the support that you have, using industries, CBC and people like that who can help and bodies that can help. There are for small businesses, there's a small business compliance code, which actually helps identify or just acknowledge if there is any underpayments or go through that. So if you are a small business, so that's less than 15 employees, definitely have a look at that code because that provides a really clear checklist. If you do get it wrong, we are talking it's quite serious, so it's fines and imprisonment. So that is quite serious, quite scary for something where there's so much information out there to help.
Now, the fines and imprisonment are if you get it wrong intentionally.
Intentionally.
If you make a mistake with your payroll or something doesn't go right, what's the advice? What do you do?
So I would use, if you're a small business, use that compliance code and you can actually reach out to Fair Work. And what they will do is they will work with you. It's kind of self-reporting. So you've reported it. I've gotten it wrong. This is what's happened. And they will kind of, work it out. But as soon as you've identified it, if you've reported it, you're fixing it, you're taking the steps, you're not going to do it again. So definitely small businesses, the biggest thing I would say is look at that small business compliance code. If you just type it into Google Fair Work, small business compliance code, it'll pull it up. And it's a really good, it's like a little booklet and it runs you through that checklist. And even if, you're sitting there and you don't know if you're paying people wrong because, again, you don't know what you don't know. I would always recommend grab a sample of employees and, you know, reach out to someone, call the advice line, and just get them to double check. Get them to double check the hourly rate, make sure that's okay. And that's the easiest way to do. Grab a sample, double check, and then that way as well, you can just feel a little bit more reassured. Again, if something then goes wrong down the line, you've kind of got evidence where you have actively sought to make sure that you're doing the right thing. Because again, it's the intentional. If you're ignoring it, living in just, if I don't look at it, I won't know. It's hard to say where that sits with the intentional.
And if you have made a mistake, it's one thing to sort of deal with fair work and so forth, but in terms of managing the employee, what's your advice? Just to get on and fix the problem in the short term?
Get on and fix it. It really depends. It's always best to communicate to the employee, but you want to make sure that that communication is right because you don't want to kind of open up floodgates for every employee in the business thinking that they've been paid incorrectly without having more information. So I would say if you have worked out that you've got something wrong and it might impact some more people, I would always say you know, call the advice line, get help just in terms of even how to word it, how to phrase it, because we have seen in the past where someone will be like, oh, we got this wrong. They just go straight innocently to the employee. They've maybe minced their words a little bit. So then that employee talks to others. You then got all the employees in the business thinking that this business has done something really badly by them. They're underpaid them. It then just becomes messy. So
Mm.
communication is key, making sure that you have that communication, but also making sure that that communication is right.
And of course, the best way to not get into these situations is, of course, to get it right in the first place, which
Yes.
is a whole minefield in itself. So, what's your recommendation for businesses to make sure that they are, in fact, complying? How do we get it right in the first place?
Yeah. So getting that support or using the resources when you're hiring. So not once you've hired, because I think that that creates ambiguity for, when you're in that hiring process, you want to be clear what you're going to pay someone. You want to be clear what the terms and conditions of their employment are. You don't want to then go through that process, have a successful candidate, and then them not agree. So really key to get it even before I'm thinking about hiring this role. I need to see what their rate is. Are they covered under award? What does X look like? What does Y look like? Are you having bonuses? Are you having commissions? And you can go into Fair Work, you can do your own research. Sometimes that can be hard if you're not really across it or too familiar with it, or it might be a little bit more of an intricate role. You can use the advice line, can help guide you there, but there are so many resources. There's Pact. If nobody's heard of that, it's the pay and calculator tool on Fair Work. So that's pretty straightforward, streamlined. Again, nuances, I'd call the advice line, but just use the resources. There are so many.
Excellent. Good advice there. Now, one of the questions that's kind of changed, or one of the things she's changed over the last couple of years is the definition of contractors versus
Mhm.
employees. And obviously, there's different payment arrangements that need to go into there in terms of wages and so forth. But how should employers differentiate between contractors and employers now that the law has changed?
Yeah, so it's kind of it shifted a little bit from one case and then it's gone backwards. So I shouldn't say backwards, but it's reverted to the original definition. So it's really looking at the the practical reality and true nature of the role, so and the relationship between the parties. So going back to that multi-indicia test, so level of control, form of remuneration, what is the working arrangement, what are the terms, and that totality of the relationship between the parties should really, and the terms should outline, are they a contractor by nature, are they an employee by nature, and then making sure if they are an employee, you're paying them correctly. If they're a contractor, you're treating them like a contractor.
Yeah, and we have some great resources on our website at
Yes.
canberrabusiness.com for any members who need to access them, or our advice line's always there, of course, to help out. Now, I'm sorry, I've been remiss. I should have said at the beginning of this webinar, if you do have questions for Tian, just do drop them into the Q&A function at the bottom of your screen there. We'll get to those towards the end. Um, but pay and entitlement is obviously absolutely critical, but so is managing leave. So let's talk a little bit about leave, which I know we get lots of calls in from members about as well. What changes to employment definitions might impact who's eligible for personal or carers leave in the first instance?
So, not so much probably who's eligible, but how it shifts. So, it might be if you've got a casual employee who actually is a systematic casual, may move into a permanent role. Firstly, as a systematic regular casual, they may be eligible for parental leave. So, that's one key thing in terms of personal leave, carers leave, annual leave, it still sits within the normal amount. We have had the added of the domestic violence leave. Domestic violence leave is able to be accessed by casuals, and that is paid. So that's probably a key portion. But then casuals are still entitled to their unpaid carers leave. So remembering that you cannot um, you cannot take action against a casual for taking personal leave. That might be them rejecting a shift due to being unwell. You can't then terminate them on that basis because they do have that entitlement, although it's unpaid.
Sorry, I'm muted apparently. That sounds like a little bit of a minefield for employers in terms of casuals and domestic violence leave. So,
Yes.
what you're saying is that a casual employee is entitled to domestic violence leave, but how does an employer um, kind of know that entitlement is there? Because the casual could reject the shift at any point right up until the start of the shift, right?
Yeah. Yeah.
Yes.
So it's not to catch employers out. So if you don't know that someone's been going through that, they've not been explained, there's not been anything to you, it's just them rejecting the shift. It's for those when somebody might be really struggling, really saying that they actually, and the purpose of the leave, I should go backwards, the purpose of the leave is for them to be able to use that time to seek support, seek help, find other arrangement, whether it's moving house, whether it's doing something. So I shouldn't say typically, it's a really difficult subject, but I've had experience where people have explained that to their managers, even casuals. I've, had experience with team members who have, there's kind of they hint towards it and you just really pick up on that and maybe go a little bit further. Is everything okay? Again, with the some things come up with the evidence, and it just needs to be what's reasonable. So I think just using, again, different to personal leave, using your instincts. If you are unsure, call the advice line because it is such it's a sticky area. You don't want to get it wrong. It's serious impact. If you do obviously get it wrong, it can really impact someone's life. So when unsure, if it's not sitting right with you, you don't know what to do, call the advice line, look for resources. But yeah, if they're not telling you anything and they've just declined a shift, this might be going on in their personal life, then there's nothing you can do.
Okay. Now, when you've got sort of moving back, perhaps just to sort of personal and carers leave more generally, when you've got an employee who is frequently absent, if you've got
Mhm.
recurring absences, how do you manage that? What's best practice for requesting evidence while staying compliant and respectful?
So I think the first key for me would be having a policy. If you have a policy in place, it's something that you can revert back to. It means that there was an expectation on the employee when they started working to read that so they understand the parameters in which you're going to ask. So a lot of policies say something very general, like if you're away for 2 days, consecutive days, or you need to provide a medical certificate, or otherwise at the business requests. So having a policy, you can refer to it in those instances. If it's if maybe it's that one instance, but they've just had a lot. It's about being fair considering the circumstances and just being reasonable. So, you know, could you please send through a medical certificate when you get a moment, just so we can process the, you know, pay run? If you're not sure where it sits in terms of that might be unauthorized leave. So what can happen is if you've got someone doesn't tell you that they're taking personal leave, they haven't given you any evidence, it may be unauthorized if they've exhausted all their paid leave. So when you have a policy that clearly outlines this, it's going to assist someone running a business or managers to then direct it there and say that they're not just kind of making it up. And again, there's always, it can be a difficult scenario they're working with. So reach out to, I'm going to keep saying resources advice line, because we can help with the wording. So it might be that somebody keeps taking leave. We can help with what does that wording look like when you go back to that employee and you have something, you know, you want to ask them for a medical certificate, or they're not providing something, they're not providing the evidence.
Yeah. Now, on the flip side of that, if there are issues with presenteeism as well. If you've got someone who's really sick, who's really committed and really shouldn't be at work, how are you best to manage that sort of as a situation?
So having those conversations and then down, look, we know that you're committed, acknowledging them, then saying it's really important, your health and safety, you need to get better. We need to take the time. Personal leave is there for that reason, for you to be able to step back. You know, if they're really sick, they're in an office space, making sure that they're not making their colleagues sick. If they're at home, one of the things that from COVID is kind of come out is people sit at home very sick, but because they can work from home, they still work. But then the output's not the same because they're very sick. So it's having those conversations about, look, I understand that you want to keep working. Personal leave is there for that. You're not able to do your job. If it might be them trying to, you know, adjust some of their role to suit them being unwell, that's where you can kind of jump in and be like, look, that's not part of your role. You really need to be able to do X. If you can't do X, then that's highlighting to us that maybe you need to take some time. You need to take personal leave. It can be harder if they don't have that leave, or there are a lot of leave hoarders, I guess, out there that really don't like taking leave. And it's just explaining that that's there, it's its purpose. It's the same when you come to an excessive annual leave accrual. That's something that the employees can actually then direct an employee to take leave. And that's key because the purpose of that, again, is so employees take a break from the business. So they're not getting that fatigue. There's a reason why we have that.
Absolutely. Now, there's a couple of questions that have come in from our viewers online here. So, 2 weeks paid leave for domestic violence for a casual, is that based on the average number of hours or the full 38 hours a week?
So my understanding, and I would probably need to double check, is it's just 10 days per year. It's 10 days flat. That's the same 10 days.
For everyone.
Yeah.
Okay. The second question is about the resources section. What resources are there for me to have a look at? And I guess the answer to that is on our website, we have a workplace relations hub. There's a series of resources available there for our members to have a look at. And additionally, our advice line is there for business, corporate and principal members of the chamber to access. But just reach out to the advice line essentially if you need any advice or support. Tian, let's move on and talk about parental leave on the subject of leave. Now, parental leave rules have evolved quite a bit over time. What are the key updates that employers need to understand?
So part of it is the notice. So the notice for starting parental leave and the confirmation date. So it's 10 weeks written notice before starting parental leave. So that's on the employee's side. Again, if you don't have a policy for parental leave, I wouldn't leave it solely on the employee. I would be, as the employer, just checking in, following up if it's approaching that 10 weeks. Confirmation date of the leave, so the date that they're going to officially be off, needs to be at least 4 weeks before the leave starts. And I did say this earlier, but again, remembering that regular casuals may be eligible for this leave. So if you do have a casual that's working regular, working systematic, don't just assume because they're a casual, they're not eligible to the leave.
Okay. Now, the leave itself, the paid parental leave, is paid by the government, right? So the employer doesn't need to worry about that. But this is about
Yes.
keeping jobs open and available for
Yeah.
employees to come back
So
to.
that there is kind of a overlap where I know a lot of people get confused, and I know even people going on parental leave get confused, but there's a an amount that's paid by the government, but then some employers choose to also pay parental leave. So there's an unpaid, what we call unpaid parental leave, actually is partly paid by the government. But if an employer chooses to pay parental leave, that's it separate. If you've never done parental leave, you've got someone coming up that has parental leave, have a look at Rota. You might need to register because of how it works. The employee submits their leave through Centrelink, and a lot of the times, I'm pretty sure I haven't personally dealt with it for a few years, but what would happen is the government would then pay the employer, and then the employer would pay the employee, but they need to all be registered through. So go have a look at Proda.
Excellent. Good advice there. And I guess just for clarity, does that entitlement also apply to non-citizens if it's being paid through Centrelink? If you've got someone here on a temporary visa, for example?
That's a really good question. I would actually need to double check that in terms of the Centrelink portion of it. But from the eligibility standpoint, because again, we would work off the eligibility for somebody to be able to take leave if you have been with the business for at least 12 months before the due date of the due date, then you would be eligible for that leave. Whether you're then eligible to actually physically be paid by the government would be the government side. So I'd need to check that.
We'll check that out and put something
Yeah,
up
that's a
on
really
the,
good
on our
question,
website
though.
around that. But of course, from the employer's point of view, it's not material. Um,
Yeah.
so the leave entitlements apply, but what about flexibility? How should businesses manage requests to return to work part-time or work from home as people are coming
Yeah.
sort of through their leave process?
So this is something that some businesses do really well, some businesses do really badly, and it is something that is really focused on. So flexibility, when you have someone who's entitled to make a flexible working arrangement, you're really hard pressed as an employer to just flat out reject it. They even changed the rules to say that you can't just reject it. If you're rejecting it, you have to put forward your reasons as to why and propose, make a new proposal. So they've stopped where a lot of employers were just saying, no, we can't do that. So they've changed it that you have to say why. And it needs to be reasonable business grounds. So reasonable business grounds is not suit that, oh, we don't like the idea of you doing that, or, that doesn't really sit well with us. It needs to be, is there going to be a loss for the business? Is it not viable? So a key one might be a receptionist that greets employees, that sets up meeting rooms, that, without looking into the details, that's something that needs to really physically be in the workplace. So if they're putting forward a flexible working request to work from home, the employer would need to look at, okay, a lot of their work needs to be done in the office. Are there portions that maybe can be done from home? Is there really just an admin side? So it's working with the employee and making sure that you're not just blatantly saying no. The employee that goes on parental leave, they're entitled to return to their original role. One part of this is that we'll call that their substantial role, the substantive role before they went off. That returning role, if they have asked for that flexibility, can be different, but it does not mean that you give up their original role. So if they're, easing back into their full-time hours, it may be you still need to, and you've approved them to work a few days a week, do part-time, do a slightly different role as part of their return. their original role still needs to be there. If it's gone, if there's been a restructure, the employee still needs to be consulted with because that is their original role. And that's where a lot of stuff gets murky, gets confusing, because employers can use that time to change a role.
So, what are the other things that get employers into hot water, perhaps around parental leave?
I would say that the flexible working arrangement is that really big one. So, and refusing the request. There was a case recently, which it's not got to do with parental leave, but I'll give you a really brief overview. It was an employee who's, works for a company but has been working from home because they don't live near the office and they've been taking their child to school. Then all of a sudden, the employer has mandated that people need to come into the workplace. This person was saying that that's not reasonable. They can't do it. They haven't been doing it for years, but the employer suddenly decides, nope, that's the direction. So they won that case because it was not reasonable. This employee's been working this way. They've based their life around it. They've based their, taking their kid to school, where they live to the school. And the employer just changed their mind and decided they wanted people in with no real grounds for it.
Yeah.
And that was
And the
the
lesson from that was around process,
yeah,
wasn't it? As an understanding. So you've got to
around
follow a good process to make sure everyone
yeah,
makes
follow a
changes.
good process, but also consider their personal circumstances, because that direction, if you followed a good process, could have worked for somebody who didn't have any of the flexibility needs or wasn't eligible to make a flexible working arrangement request.
Okay.
So we've got the process and just making sure that you're considering the individual's needs.
Now we've got another question that's come through around leave, so annual leave, I think. So the business shutdown period and directing staff to take leave. If employees' leave balances don't cover the full shutdown period for a business, is it okay to require them to take unpaid leave? And is there a maximum amount of leave that can be stipulated by management in terms of that Christmas shutdown? And is 2 weeks okay?
So, in short, I'm going to say no, but to be able to answer that, I'd need to see the award that employee is across. I'd need to see a little bit more information. But there were changes. I don't remember when now, but they've made it pretty strict on employees just being able to say, no, we're shut down, you're not getting paid, and directing employees to take that leave, especially if they are award covered. So for the person that has that question, I would recommend calling the advice line. If you don't know the award, we can work it out for you. Just tell us the role, the type of work that's being done.
Okay. But it is okay, just to be clear, to shut down a business over Christmas
It
normally.
is,
Yep.
yes, but it's around the directing to take unpaid leave.
Yeah. All right. Which potentially creates some issues if you don't have
Yes,
leave.
and the period of time that you shut down and so on. There's so many different kind of elements
Yeah.
to it. Yeah.
Okay. All right. Well, do just get in touch with our advice line. Contact details are on the website at canberrabusiness.com if you need more information on that. And it sounds like the answer varies depending on the employees concerned and the category of employment and so forth. Let's move on to our final issue that keeps coming up through advice line calls, and that is around managing ill or injured employees and the wellbeing and compliance associated with that. And obviously employers here need to balance empathy with compliance, and most employers want to do the right thing, I think, Tian, but sometimes it can be challenging to kind of get that right. So obviously a whole lot of legal changes over the last couple of years. What do those reforms mean for employers managing ill or injured staff?
So it's really around the general protections, or two elements when we're dealing with different legislation. It's around the general protections. That's one element of it. So when an employee makes a claim due to adverse action, And it's also about looking at the how someone's assessing the return to work. So I believe the assessment of the return to work, and that's under the new workplace rights bill, that we're still waiting for a little bit of clarity or the actual act to be written. But in in summary, or to summarize it, an employer must really make sure that they're identifying, assessing, controlling risks. So that means looking at when an employee is returning or when they've been ill, when they've been injured, that they're managing it on an individual and tailored basis. So don't just have, a blanket approach to everyone that's injured, say that the person who broke their arm is the same as the person who broke their leg on their return, because depending on the role, that could be very different. Consult with the treating practitioner. So, really making sure that you're having that conversation. Generally, it's through giving them an outline of the job requirements and having them comment on it to see if there are reasonable adjustments, not just going back to blatantly say no to everything, because there might be things that an employee can do within the scope of the role, and making sure that it's timely. I believe the bill, one of the updates was in the time frame in which you must respond. Memory, I want to say it's about, I want to say 21 days, but again, the bill has not been, the bill's been passed, but the act hasn't been written. So that's probably something that's going to come out earlier next year to provide, there's going to be more comms, more clarity on all of that, but that you are responding. So if you get something that says, I've broken this, my doctor is saying that I can only do X, Y, Z, making sure you respond to that. If that's not feasible, why is it not feasible? Is there another adjustment that we can make? And the adjustments don't need to be permanent either. So I think making a reasonable adjustment, having it clear, I always recommend doing like a month time frame. Okay, these are your adjustments for this month. This is how you're going to work. And having a clear understanding between the employee and the employer, if something's hurting, if you're struggling, if that's where we stop, we have a discussion, we might need to reach out to the treating practitioner again.
And when should an employer seek medical evidence? And what happens if you don't agree with the assertion that's been put forward? Can you go and commission your own doctor to come and have a look?
Yeah, so you can definitely go and do your own IME, so the own individual. It is very costly. So as soon as you're directing an employee to get that information, it can be a costly exercise. I haven't seen many cases where they really don't agree. The only time that that can happen, because it's when it's probably the less obvious injuries, is if it's mental health or in that space, because it's not as obvious as to what the injury is. There can be some wanting to clarify around that. What I would say is, if you're physically seeing someone struggle with their role, that would be one reason why, if you're not getting the information from them or they're not telling you, and you can see a concern. If there's been a change, and again, you're not getting the information from the employee, if someone's returning from a long period of absence, if you know that they had an operation, if, it might be just, okay, on your return, you've had X amount of time off. Can you just provide us with something from your treating practitioner that just outlines that you're, fit to return to work as usual? Or what adjustments do we need to make in the workplace? And if there's, just have that communication around if there's any difficulty with performing their normal tasks. So if someone is struggling and you see them struggling, reaching out to them, hey, are you okay? Anything we need to be aware of? Anything we need to be across? If anything changes. And once you get that work safe culture in a company, my belief is that that kind of happens naturally. If you've got that really safe work culture, if a colleague sees someone struggling, they're going to say something.
Now, in some cases, of course, it's not feasible to get someone back after they've been ill, or perhaps having very prolonged absences that don't have good reasons associated with them. And sometimes employers do need to terminate people. What are the risks around moving too quickly
Mm.
with that process, and what advice have you got?
So there's a few risks because it depending on where they sit. If they're on a work cover claim, there's actually per state, there's a set period of time that protects the employee from being terminated. So that's one thing. Another one is if you're terminating them just on the basis because they've taken too much time. Again, there's kind of a temporary absence where someone is somewhat protected because they haven't taken enough leave for them to be considered to be absent for a long period of time. And then we have, you've got penalties under workers' compensation. So if you do take action against them, unfair dismissals, general protections, because general protections, you could be seen as terminating someone for the basis of them using their leave, their entitlements, also human rights. So remember, that's another ball game that can be quite confusing is if you're treating someone differently, you're taking action against them for, an injury, an illness, and then the reputational risk for the business. I always say reputational risk is quite big because we do live in a very a time where everyone shares everything online and people can be cancelled so quickly and being asked to fix things so quickly that reputation comes in quite high for me.
So tread carefully is your
Yes.
advice, and
Yeah.
always check
Because
in with the
there
advice
might
line.
be one thing where it's okay, we believe we're doing the right thing. They've been away for a long period of time. But if they've been away for a long period of time for an injury, but you've approved them to use their annual leave, you've approved that leave. So you can't then take action against them. So there's a lot of different moving parts. I would always say if you've got someone who's a long term absence, reach out for help. If you've got someone with an injury and you believe it's going to be long term, just reach out for help because there are so many just nuances.
Excellent. Some good advice there. So, I guess I'll just put out a final call for any further questions from our audience. If there's anything anyone wants to raise, this is your good time to sort of drop it into the Q&A there. But Tian, just to wrap up, I guess, if you could give employers one piece of advice on how to proactively manage issues around workplace relations, what would it be?
If I had to narrow it down to one, I'd say policies. As much as people kind of see it as a bit of an annoying thing, a bit of a stupid thing, they can just be such good baseline to be used every single time we go into an unfair dismissal or general protections claim. What we are looking at is the policies, the procedures, what is governing, the employment contract, because policies and procedures also govern that working relationship. So have them as just a baseline. Even if you've got a small business and you think that it's silly, have just the basic ones. And there are templates of these on CBC.
Yeah, we've got a range of
Yeah.
materials available. So if you need those, just have a look at our website or reach out to us if you can't find what you're looking for. Well, Tian, thank you so much for joining us this morning. It's been really helpful, I think, to unpack some of those big issues that come through our employer assist line. So to our audience, I hope this has been useful for you. Do reach out to our employer advice line if you need assistance. 1300 277 881 is the number. And sorry, we do just have one last question just
Mhm.
sneaking in at the end there. Substance abuse. Is substance abuse considered a mental health matter? And once they've completed rehab, are they entitled to extra flexibilities?
Good question. Um, I I don't know if it would be a mental health one. That's actually really good. If they've completed their rehab and everything, look, with this, I'd want to know more about it. I'd want to probe more about it. I'd want to understand did this impact their work? Is this purely something outside of the workplace? I think it's one that could potentially sit into physical and that psychological, depending on how it operates. Then coming back in terms of flexibility and requesting a flexible working arrangement, I don't believe officially under it they would fit within the criteria because it's someone who has a school age kid, someone who's above the age, I think it's, I want to say 45, but that sounds very young. I need to double check that. If they don't fit that requirement, but separate to an official flexible working arrangement, I'd consider what can you do to just support their return.
And I guess, I mean, there's a correlation, but they are between mental health and substance abuse in many cases, but they are different issues in themselves, right?
Yes.
So again, reach out to our employer assist advice line if you need to talk through the specific matter on that. Is probably the best advice. Yes. All right. Well, Tian, thank you so much for joining us this morning. I hope it's been really helpful. We're recording this webinar at the end of 2025. Coming into 2026, we'll be doing at least a couple of HR Connect events for members here in Canberra. So hope you can get along to those, and we'll see you in the new year. But in the meantime, Tian, thank you very much for joining us.
Thanks, Greg.
Thank you.
Bye.